First, I'd like to pass the floor to Oleg Kalatilov. To give you just a very brief overview of what's going on in Russian courts right now with regard to the Lugovoi law.
Yeah, so before we start analyzing the impact of Russian litigation on foreign proceedings, we should first briefly discuss the ways of how you can get to Russian court. So actually, as you probably know, in 2020, Lugovoi law was introduced, which which includes additional grounds for jurisdiction of Russian courts. So the situations where the Russian court get jurisdiction where previously they didn't have the jurisdiction. And there are two main groups of cases where the Russian court received jurisdiction according to Lugovoi law. So these are the cases involving sanctioned persons and cases following from sanctions. So cases based on sanctions. So the first group of cases involve, as I told, involves cases involving sanctioned persons. So these may be any persons. So these may be Russian persons. These may be foreign persons from any country. These may be any sanctions except Russian sanctions. Most notably, this may be Ukrainian sanctions, because Ukraine has a very vast sanction program. So Ukraine has sanctioned much more people and companies than foreign countries. So, this right of sanctioned persons to litigate in Russian courts applies even if the dispute has no connection with sanctions, and even if the dispute does not affect the dispute resolution procedure. So the only limitations is that this should be Russian-related sanctions. So any sanctioned person affected by sanctioned by Russian-related sanctions may bring the case to Russian court. And so the second category are the cases following from sanctions. And most notably that these grounds apply also to the cases where you have the dispute resolution clause, where you have the arbitration clause, or where you have the prorogation clause. So despite these clauses providing for jurisdiction of some non-Russian court or arbitration, you are allowed, according to the law, to break these clauses and to bring the dispute to the Russian court. The only reservation here is that the sanctions, if you have a clause, the sanctions should prevent access to justice. And in this case, the Russian court would deem that prorogation clause or arbitration clause unenforceable. And that would be a basis for the Russian court to take jurisdiction despite this clause. What these obstacles can be? For instance, it's impossibility to make payments regarding to the dispute resolution procedure outside of Russia. So it's the situation when some law firms refuse to take assignments. These limited visa availability, so limited travel options, and also the risk that the foreign court or foreign arbitration would apply sanctions, which is considered by Russian court as a limitation of access to fair justice. So, and there is also the position that these obstacles, they shouldn't be absolute. So there may be some obstacles, and proving some obstacles may be a ground for the Russian court to take jurisdiction despite arbitration clause or despite prorogation clause. And most importantly, Lugovoi law cannot be waived. So you cannot write in your dispute resolution clause that, well, we agree, we know the sanctions, we agree for the jurisdiction of some foreign arbitration or foreign court. So, well, technically you can write it, but it will be ignored by the Russian courts. And also in non-friendly countries, so in the countries that apply sanctions against Russia, the access to justice is deemed to be limited. in this respect, for establishing jurisdiction of Russian court, there is actually no difference whether you have not the arbitration or prorogation clause, because now the courts presume that the access to jurisdiction is limited. And even in friendly jurisdiction, you can prove that you have limitations on access to justice. For instance, you cannot make payment and so on. And next I would like to discuss the situation of how you can find yourself in a Russian court. So for instance, you are the company in the United Arab Emirates and you have concluded a ordinary sale and purchase agreement with some maybe even Western country. So with a company from some Western country, from a non-Russian company. So how you can still find yourself in a Russian court? For instance, this company may be purchased by a sanctioned company or individual. Or some sanctioned company or individual may get control of that company in a way other than purchasing that company. That company may be sanctioned by Russian-related sanctions. For instance, it is established that that company makes deliveries to Russia. It may be sanctioned, and you, having concluded, Emirati firm having concluded a contract with a non-Russian firm, due to the sanctions can find itself in a Russian court. The contract itself may be affected by Russian sanctions. For instance, if it's sale and purchase agreement and the transit comes through Russia, and for instance, the transit becomes impossible due to Russian sanctions, even if you're an American company and your seller is from Western country, still the contract is deemed affected by sanctions. And that is a ground to establish the jurisdiction of Russian court. And one more possible way is a situation when the payment is affected by sanctions. And if your dispute arises from the failed payment, this may also be qualified as a case following from sanctions and be a basis to establish jurisdiction of a Russian court. And we have vast statistics of applying the Lugovoy law. So these are several hundred cases a year. So there are around 400 cases in 2024 and 350 cases for the first half of 2025. So the number of the cases is increasing, and usually they are for a very significant term. And apart from departing from the dispute resolution clause agreed by the party, Russian courts also practice ignoring the choice of law clause. They do it by the following way. So they qualify, so the claimants, they qualify the claims, which are actually contractual claims, they qualify it as tort claims. And when qualifying them as tort claims, they also claim that the consequences of the tort occurred in Russia. So it applies mostly to Russian parties. And the consequences of the tort having occurred in Russia is interpreted by, wrongly interpreted by the court as a ground to apply Russian law, thus departing from the law initially agreed by the parties. So this means that you may unexpectedly find yourself in a Russian court on a ground of which you didn't know, and on the ground which and that would not qualify as submission to jurisdiction, because before pleading on the merits you have already made a reservation that you don't recognize the jurisdiction, and you can also appeal the judgments on the basis of lack of jurisdiction, despite you have pleaded on the merits. And also, when pleading on the merits, you'd be able to present all your arguments, and if they are not accepted, depending on the jurisdiction of enforcement, you can plead that the public policy of the country of enforcement was breached, so the judgment should not be enforced, or there was no fair trial, or that the parties were treated unequally. And you can oppose enforcement by making all these arguments. But to do this more effectively, you should first state all these arguments in Russian courts. And also, depending on your contractual framework, you may even be obliged to defend yourself in the proceedings. For instance, for the purposes of recovering insurance, because a lot of insurance contracts say that you should dispute all claims. Or, for instance, for the purposes of recourse, or if there is some other contractual ground effectively obliging you to defend your case.
Hello, everybody. Thank you, Oleg. I will add that presenting of the detailed arguments on merits of the case in Russian proceedings may be aimed not only at persuading the court, Russian court itself, but at provoking the Russian court to disclose the political motivation of the judgment. Since in case when there are no objections on merits, it's quite easy for the Russian court to say that the case was presented by the claimant, no objections were presented, and with a couple of paragraphs come to conclusion. But when the detailed breakdown of the counter-arguments is presented by the defendant, the Russian court has to either rebut them in detail and consider those arguments in the decision, and usually the court has no purely legal arguments in this respect. Usually the court has to refer to the political arguments, to the sanctions as it is, or the court has to omit mentioning the arguments of the parties. And I think that the most interesting question in this respect is whether such breach of the material law by the Russian state court may be a ground for recognition or for refusal to recognize and enforce this judgment abroad. In some countries, it may be qualified as breach of public policy. There are different approaches in this respect: the broad public policy or narrow public policy of the country. And
so my question to Alex, so can you give us like not just examples, but maybe the kind of cases where it's still possible to win for a foreign company against a Russian claimant?
Well, I think they may be classified in the following groups. So first, if there is also a Russian co-defendant, for instance, some payment was blocked, and the claim is filed against all the banks involved in the chain. So against the Russian bank and against the foreign bank. Yeah, and in this case, the courts often dismiss the claims to the Russian bank because they say that there is no fault of the Russian bank in the blocking of the payment, but not necessarily affiliated. That may be just the chain. They say there's no fault of the Russian bank; it didn't block the payment, but at the same time, the claim is also dismissed against the foreign bank because they are in the same position. I think there are also other examples, for instance, where some payment is blocked or some assets are blocked in Russia, and there is a procedure in Russian law how to unblock them. And the claimant, instead of following the procedure or having missed the deadline to comply with the procedure, instead files a claim against the foreign defendant. And in this case, the foreign defendant says, well, sorry, you had a specific remedy, you didn't use this remedy, and that is why your claim is dismissed. So I think there are examples. I think Nikolai has more examples.
Yeah, I will just refer, for example, to the JP Morgan case in the Supreme Court, which our team won recently, where the court supported its previous position on Citibank case, saying that there are, first of all, very significant obstacles with satisfaction of claim to the Russian subsidiaries, and the very strict test should be applied in case of bringing liable the Russian subsidiaries for its parent companies. and also reminded to the courts, lower courts, its own approach of the Supreme Court of 2023 about the need to get an unblocking license, about the absence of tort. So since I will say in 80% of the Russian sanction-related cases, the claimants referred to the tort, and this previous Supreme Court position are very beneficial for the foreign defendants. Also, I will say that sometimes it's not clear whether obligation is really exists and whether party A has an obligation before party B, or party B has an obligation before party A, like in a, yeah, like swap transactions. And in such cases, it's a very big problem for the Russian court to satisfy the claim swiftly, as you know, since it's very easy to say that this was blocking of funds and this is a clearly not fulfilled obligation because of sanctions, and that's why it should be satisfied. It's very easy for the Russian court. But in case when the relations are quite complicated and it should be actually proven that initial obligation exists, it's still a good ground for the defendant to protect their position.
Thank you, Nikolai. So maybe to summarize, I think we can draw from this recent Citibank and JP Morgan cases two quite important conclusions. The pattern is quite similar in all these cases. So a Russian claimant brought a claim against a contractual debtor and joined as a co-defendants 2, 3, 4 Russian affiliates of this contractual debtor. And in most of the cases, these affiliates, they had nothing to do with the case. So they're just an affiliated, that's it. And so the court approach was quite unified, that because you are in the same group of companies, that's your fault and that's you also liable, and that's enough to hold you liable. But recently, especially with JP Morgan case, it was judgment of the Supreme Court was published 3 weeks ago. So it quite clearly said that two things. So that's first, that just affiliation is not enough. So you should prove that this Russian affiliate is not really independent legal entity, but was used just as a corporate front. So that's why we can violate the basic principle of autonomy of a legal person, only in this case. And second conclusion, that if there is a possibility for a Russian claimant to apply for a foreign regulator license, like OFAC or any other regulator license, to release your assets, and you didn't apply, so it means that the tort has not occurred because you have not exhausted all the ways how to minimize the consequences of the wrongdoing. So it means not complete change in the trend, but it means most likely that the trend will be not as negative towards Western companies as it used to be during a recent couple of years.